Welcome to Practical, Clear Guidance on Business Law, Probate and Estate Planning with Meents Law.
Welcome back to Practical, Clear Guidance on Business Law, Probate and Estate Planning with Meents Law. Frank Meents works with individuals, families, and small business owners across Northern Illinois on estate planning, probate, and business matters. I'm Leann Lyon, and today we are talking about whether a will is enough or a trust actually makes more sense for some situations. Hello, Frank.
Hey, Leann, how are you doing today?
So good. Frank, can you explain to us right up front the difference between a will and a trust for an Illinois family?
Sure. The will essentially is a roadmap or a blueprint for a probate judge. It tells the judge who's going to handle the affairs of the estate, the executor of the estate, and where the assets of the estate are going to go after all of the debts of the estate are taken care of. A trust, on the other hand, is a more private contract style document that keeps an estate out of probate. Typically, people who have a trust still have a will. It's called a pour over will, kind of as a backup. However, the assets that are in the trust stay out of the probate process and are distributed by the trustee as opposed to an executor, and they're distributed in the manner in which the individual who had passed at that point wanted them to be distributed.
That is one of the clearest, simplest descriptions I've ever heard. That was beautiful. Thank you. In your experience, what kind of families or situations are usually well served by just a simple will?
Well, if probate avoidance isn't an issue, if you don't mind your estate going through the probate process, then a will may be right for you. If you don't own real estate, then a will may be right for you. If you have a small estate, a will may be right for you, or a small family, a will may be right for you. A lot of times, an attorney who is experienced in probate matters and or estate planning can really help guide you to tell you which way is the right way. And oftentimes, through the consultation process with an attorney, you can get the feel pretty quickly which way you're going to be leaning. And oftentimes, my clients or my potential clients already have done quite a bit of research by the time they get into my office.
For sure. So, what circumstances then tend to push the conversation more towards a trust instead?
When people have business ownership interest, when there's a couple who has a blended family, uh, if probate avoidance is important, oftentimes people have gone through the probate process recently and they don't want their kids to have to go through that process. So that's probably one of my larger referral sources, the probate process itself. So those are just some of the drivers of choosing the trust route.
So, you mentioned that probate can actually be a driver for people to pursue a trust. Why is that?
Just the amount of work that's involved. I think a lot of people misinterpret what's involved with as an executor. Oftentimes people think that it's kind of just the reading of a will, like you hear about or see on TV, and it's really nothing like that at all. It's really more like a project management role. You are managing finances and paperwork and attorneys and taxes and family members, all while you're grieving. And you wrap all of that into the process, and uh, along with money does very strange things to people. So people that you've known all of your life, um, money gets in the way sometimes, and unfortunately, I've seen it happen too often where it ruins relationships.
Yeah. I think a lot of people assume, though, that speaking of money, that a lot of people are only useful for very wealthy families. Is that true?
No, not at all. Not at all. I think that is a common misconception. I know when I was younger, you'd hear of trust fund babies, or you'd hear of of trusts on TV, and it was the ultra wealthy or the wealthy people who had trusts. And so, that's where you think, oh well, I don't need a trust. I don't fall into that category. But it's not really about the size of the estate. It's really just about the efficiency and your control of your estate, how you want it to be distributed, and if you want the efficiency of a trust as opposed to the inefficiency of the probate process, the lengthy probate process at that.
What about children? Do children factor into wanting a trust instead of a will, or where does that usually lie with families?
Children sometimes factor in when they have input. Oftentimes, they will influence their mom and dad to get a trust because they have had friends who have gone through the probate process, or they've heard about the probate process, or they've just gone through an estate planning consult themselves, and they've decided to go the trust route because of all of the factors that they've considered, and they've made the determination that, well, I don't want to do that with my mom and dad's estate, and I don't want to run into some of these issues with my siblings or with other people that may be inheriting from my mom and dad. And so I think we can get it laid out much more cleanly in a trust with mom and dad, and so then they can influence mom and dad that way, to do that and get that trust, clarifying who's going to handle what and how it's going to be distributed and when it's going to be distributed.
Beautiful. Minor children, does that factor or sway people one direction or the other?
The minor children portion, there's some ancillary portions of the estate planning process are related to minor children. However, in the with the trust, um, specifically, you don't necessarily want to. If you have a sizable estate, even a mid-sized estate, if you will, you don't necessarily want to put a large sum of money into an 18-year-old individual's hands or a 21-year-old's hands. I know what I probably would have done at 18 with a sizable amount of money, and that would have been a pretty cool sports car, but that probably would not have been a very good use of that money. Um, so some people would want to, and I did this for my own, would want to stretch those payments out. When my children were little, I didn't know what their financial abilities would be, so I put it in my trust so that they would receive disbursements at certain ages throughout their lifetime. And now that they've gotten older, now I know what their financial abilities are, and I can make those changes, appropriate changes, as I see fit. So, but when they're minors, we don't know what that looks like, and so we can stretch that out and make those structured distributions like that.
Yeah, yeah, very wise, especially we know that the frontal lobe is not fully developed until age 25
Right.
and a little later for some.
That's right.
So, how do assets like farmland or rental property, you mentioned business earlier, but how do those factor into an estate planning conversation?
They certainly factor in from an estate tax mitigation standpoint in the state of Illinois. We always take those into consideration. We want to make sure the flow of the assets between spouses is appropriate. The flow of the income from those assets is appropriate between spouses, and then also after the spouses are both deceased, the assets are flowing to the right individuals, and at the right time. And we have to take into consideration the tax issues, and it's estate tax issues, capital gains tax issues, and income tax issues. So you have to take all of that into consideration when you're talking about farmland, business interest, rental properties, which is like a business interest oftentimes. Um, and then you also have to you kind of intersect with business succession planning at that point, where who's going to manage that? It doesn't just stop as soon as the principal passes away. It continues on, whether it's a business or farmland or rental property. It doesn't close down the day that the individual passes.
So, what steps tend to get missed after a trust document is signed? Is it just good to go?
Typically, funding is the primary step that gets missed. Um, the funding the trust is critical. Moving assets into the trust, real property, deeding real property into the trust, retitling bank accounts, some bank accounts over into the trust, pointing other assets into the trust with payable on death designations, other beneficiary designations from other types of accounts. Um, and then beyond that, I would say sticking it in a drawer and never looking at it again would be another mistake. You don't have to take it back to the attorney who drafted it on a monthly or annual basis. Even just take a look at it and treat it kind of like you did with your employer's health insurance programs. If there's a major life event, consider your estate plan and see if there's something that maybe you need to be changing. If there's a birth, a death, a divorce, anything like that impacts your family size or structure, you might want to take a look at that and make sure it still applies.
So, can you share a story or situation where the right planning structure made things significantly easier for a family later on?
Probably the best example was I had two families from the same town. Um, the both moms passed away in the same month, um, and this is a small town. And one of the individuals had a revocable living trust in place. Both of them had modest assets, a home, life insurance policy, brokerage account, those types of assets. Nothing crazy or exotic. And the other individual had a will, and the both of them had children, three children in one family, two children in the other. The family that had the trust, they came in, signed some paperwork. We did a couple of other transactions for them, deeded the property over into the children's name, and we were done within maybe 2 months or so. Um, the family that had the will, we went through the probate process, and it was about a 14-month period of litigation. Two of the three children, adult age children, stopped talking to each other. Um, there was litigation over mom's competency at the time that she signed the will, even though that really shouldn't have been a question. And and the majority of those modest assets went to the fight, and not to the legacy. And the individual who passed would have never wanted that for sure. So that's probably the best example.
Oh, that's unfortunate. Well, as we wrap up today's episode, and this is for somebody who has delayed estate planning because they're not sure which direction makes sense, what usually helps simplify that decision for them?
Oftentimes it's the economics of it. If if you take a look at the cost of a revocable living trust, the pour over will, the entire trust package, if you will, that's typically less expensive than probate for a single individual. So a trust package for a couple, less expensive than probate for an individual. And that's today's rates, if you will. And I know some people will say, well, you know what? I'll be gone, so I don't really care about, that my estate will pay that.
Yeah.
But the majority of the time that people are in my office, they don't want their children to have to pay for that, even if the money is coming from the estate. So that's usually the main driver, and that turns people towards the trust.
Got it. Well, thank you. And for our audience, that wraps up today's episode of Practical Clear Guidance on Business Law, Probate, and Estate Planning with Meents Law. To learn more about Frank Meents and the team at Meents Law PC, visit mentslaw.com. Thanks for listening, and be sure to leave a review, and subscribe to the show so you catch every episode. Thank you, Frank.
Thanks, Leann.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.